Thank you for attending. My name is Kevin O'Connor. For those I haven't met, my daughter had a hemispherectomy about 9 years ago, and I've been working as a parent supporter with the group. So I have the pleasure today of introducing Dr. Heather Connors. Uh, Dr. Connors is a gerontologist and advocate for ethical guardianship. Her vision for educating and supporting professionals and family guardians has come to life at the Center for Guardianship Excellence. As executive director, Heather leads research projects that help to reveal facts about the needs of seniors, adults with challenges that can be described as incapacity, and communities. This research can be downloaded at the center's website. So without further ado, I welcome Dr. Connors.
Thank you. I'm really happy to be here, and I'm excited to be talking to you about a topic that I think is so important, and it's one that so many people have questions about. So I definitely do have a presentation prepared, but if you have questions, put your hand up and I will make sure I get to them. So I'm just going to go ahead and get started. I will let you know that this is not legal advice. This is meant for educational purposes only. If you have a legal question, you really should be speaking to an attorney. So why are we doing guardianship discussions at an epilepsy conference? And I think the real reason is that so many of you parents are so involved in the everyday decisions of your child's life. And that is natural, that feels really good, it works really well in your family. But when you have a child turning 18, all of a sudden you do not have automatic access to that person's decisions. And so there needs to be situations put in place, whether they be waivers or whether they be a formal guardianship situation, in order for you to remain involved. And so we want to make sure that you have access to medical information if you need it, that you're able to sign whatever paperwork comes up. Sure. Yeah, they're right up front. Great, thank you. So that you're able to sign whatever paperwork is necessary. You can represent your child in whatever way is necessary. So as much as we expect it, and this is some research that we're doing right now, so often family members don't take the necessary steps to get a guardianship in place because they assume, I'm the mom, I'm the dad, I'm going to be able to make these decisions. And that's actually not how it works. So we want to make sure you have the tools in place that you need. I'm going to start with a handout that's in your handout. That really kind of talks about what guardianship is. And I won't spend all that much time going through it. There's 14 points that talk about what guardianship is. But let's talk about just a couple things here. First, you should know guardianship is put in place when an adult is not able to make or understand informed decisions. And so this might happen when a medical situation comes up. Maybe somebody's in the hospital. Maybe the primary care physician is saying, you know, it's time to transfer to an adult provider. We really need to get your steps in place. Maybe your child is transitioning out of high school, and the high school team is saying, all right, it's time to get your ducks in a row. And this is really often where those guardianship conversations come up. I'm going to mention that guardianship should be a last resort. So best case scenario, you're able to do a supported decision-making agreement. And I don't know if any of you were able to be at the supported decision-making session yesterday. And that is a much more informal way of doing things. It differs by state. So some states have laws in place that support supported decision-making. And supported decision-making takes place when an adult, so it could be your child, it could be a neighbor of yours, whatever it is, puts together a team to help them make decisions. Now, I will tell you that we all use this in our everyday lives very informally. So I have a son who's 10 years old who wants desperately to play football. And I'm like, I'm a little uncomfortable with that. So I'm surprised it hasn't come up in our conversation so far. I ask everybody I speak to what they think about youth football. So, you know, what about flag football? What about tackle football? What do you think? What's your experience? What was it like when you were in high school? It's really changed since I was in high school. We have these conversations all the time, but I'm not asking my neighbors to make the decision for me. I'm asking them to give me some feedback so I can make an informed decision. I'm asking my pediatrician. I'm asking my, my friends, my neighbors, everything. This is what a supported decision-making arrangement looks like. So you're able to, you as the decision maker, stay in control of your decisions, but you have a team to help you. That doesn't work for everybody. So in some situations, guardianship is going to be necessary, and so we're going to come to that. When guardianship is necessary, some medical professional needs to provide some evidence to the court that the person is not able to make or understand their decisions. And we'll talk about capacity and incapacity in a moment. But really, in every state, there needs to be some sort of medical evidence to say this is necessary. The other component, the legal component, is the adult child, the adult should be notified about the process. So this shouldn't be like, don't tell John, we're going to have this guardianship. That's not really ethical. So it's really important to involve the person in the conversation so that they're able to be part of the process. In fact, most courts, I'll say many courts, require the person to be at the hearing and be able to say their piece about what they think about the guardianship, whether there should be a guardianship, who should be the guardian, all of the pieces involved. So it's really important to be person-centered. When I started working in the guardianship world, it was when I was in college, and very often we would be named as plenary or full guardian. And really, we made all the decisions. It was like, oh, this is better for the person. They don't have to worry about these things. We know now that's not really okay. We know now that it's much better to tailor the guardianship to the person's individual needs. So if they're not able to make really complex medical decisions, but they can say, you know what, I think I have a strep throat. I think I should go see my doctor. You know, we're really trying to give them as much independence as possible. So guardianships should be tailored to the needs of the person, and they can either be temporary or long-term. So a temporary guardianship may be put in place if a person's in the hospital and they're trying to figure out, is this going to be necessary in the long term? Maybe this person has, especially with an older person with dementia, does this person have a delirium that might kind of go away after their meds are taken care of? Or is this a long-term dementia? What do we need? Let's see what happens in the next 90 days and then decide whether we need to do this long-term. We separate out guardianship of the person versus guardianship of the estate. And I will mention that in every state, the terms are different. In Massachusetts and a bunch of other states, we call a guardian of the estate a conservator. But as we saw in the Britney Spears situation in California they call the guardian of the person the conservator. So we try to make it as confusing as possible so you have no idea what you're doing. And I will tell you, just kind of as an aside, my organization, the Center for Guardianship Excellence, does support groups for guardians and for people who are thinking of becoming a guardian that are free and are online. And if you're saying, I don't even know what they call it in my state, come speak to us and we'll help you with those things. There are also additional authorities that some guardians may get. So in Massachusetts, for example, we guardians are not allowed to make decisions about antipsychotic medications and some specific surgeries, like some epileptic surgeries, without specific authority from the court. The court says, this is such a major decision, there's no turning back from it. You need to make sure that you have authority in order to do that. And again, every state differs, but you really need to know what your authority is. So it's a little bit of a gray area with families because a family member might be doing it all. But in general, your job as the guardian is to make the decision. Your job is to consent to medical situations, help the person identify housing opportunities and sign the residential lease, whatever it might be. The decision maker is the guardian's role. And that's different from the caretaker. So you may have a PCA, a personal care aide in your home who helps you with some of the personal care of the person. So again, it's a little bit gray if you're a family member, you're probably doing it all, but the roles are a little bit different. We have a code of conduct that we stand up to. The National Guardianship Association tells us how to act, and we are expected to kind of rise to those professional standards. And they teach us what those are and how to respond to those. Again, we should include our person in decisions as much as possible. That is always what we want to do. And we want to make the decision the person wants to make. And so that doesn't mean every single time you're able to make the person's decision that they want. So maybe they're making really unsafe decisions given their medical situation and you will have to kind of go in the other direction. But it's really not a good idea to just never ask. You should know the person's values. You should know their wishes. You should know what they like and don't like. We talk a lot about what is important to the person as well as what is important for the person. So it's important for the person to have a doctor who understands them. It's important for the person to get the surgery that they might need. But it's important to the person to maybe have a job. Or maybe it's important to the person to be around friends. It's really what we as guardians want to do is understand who the person is and what their wants are. And then finally, the other thing that really is important here is when you, or if you, it's really if you, determine that the person no longer needs a guardian, you should tell the court. Because that means you've done your job. Like if you get yourself out of a job, you've absolutely done your job. You have helped the person achieve independence or some level of independence. Maybe you can't even get outside of the entire guardianship, but maybe you can give them some level of decision making back. That's a win. So we really, like I said earlier, guardianship should be a last resort. If there's another option that works, best situation possible. We do need to report to the court. So that's the major difference between being a parent and being a guardian, is every state requires there's some reporting to the court to let the court know how the person is doing, what's going on with the person, what their needs are for the upcoming year. And so you may get a letter from the court saying, we haven't heard from you in a while. Everything okay? And you really try to avoid those. You never want the judge sending you letters. That's never a good situation. So really trying to know what your state's reporting requirements are and following those reporting requirements is really a good practice. And then most states have some sort of way to let the court know if there's a concern about the guardianship. So if you happen to be a service provider and you're like, I have called this person's guardian 10 times and they don't answer the phone, they never return my calls. What is going on here? Most states have a mechanism for you to get in touch with the court and say, I have a concern about this guardianship. I think you should do an investigation. And it's not like bad. It's more of a, I want to protect this person. I want to support this person's rights. Let me be involved in this care. So I'm going to give you an example. And this person's name is Artie, and he's a 20-year-old high school graduate. He works in he has a job that his parents drive him to, and he has an epilepsy diagnosis since the age of 9. He got surgery at the age of 16. He has some challenges around memory and math. He has organizational challenges, has some anxiety and leg weakness, but he has a lot of strengths. And that's one of the things that we as guardians always try to do. We have a tendency to look for somebody's weaknesses because we're trying to help them, right? Good practice is to look at somebody's strengths too, because very often there's a way for us to use those strengths to get somewhere with that person and help them address some of the weaknesses. So his strengths are persistence, hard work. He does songwriting, and he's very musical. He lives at home with his parents, and he's a single child. Mom and Dad are looking into guardianship. So they have gone ahead and started the petition, but what they haven't done yet is gotten the medical evidence. And I mentioned earlier that every state requires medical evidence for a guardianship to be put in place. Some states require specific levels of evidence if the person has an intellectual or developmental disability. And so in this case, Artie's parents need to get 3 clinicians to document his challenges.
Is that within the state needing to get 3, or is that
Yeah.
that state's?
Yes. Yep. So it does depend on the state.
Okay.
Yeah. Yeah, and that is one of the real challenges, is that every state's laws are different, their requirements are different, and it can be tricky. So knowing what it is that your state requires, speaking to your court, speaking to advocates in your state is going to be very, very helpful. So definitely need that. What I'll mention here is they haven't told Artie what they're planning. Right, terrible. Come on, mom and dad. So mom and dad, they don't want to upset him. They don't want to bother him. That's, this is just going to lead to a fight. So they're trying to protect him. And as much as we want to protect our kids, I'm going to say, it's time to involve him in this conversation, because we may be able to work with him to really figure out what he needs and limit this guardianship as much as possible. So I'll tell you in a moment about what they need to do. So I mentioned they need to get evidence of his capacity, and I'll define those terms for you. So when we talk about decisional capacity or capacity, we're talking about the ability to receive and evaluate information and make or communicate informed decisions. Most adults are assumed to have capacity unless a judge determines otherwise. Okay, so this is sort of an assumption that we have. In contrast, if a judge does make the determination that the person lacks capacity, it's called incapacity. This is a legal ruling, so I can't give you incapacity, okay? I can't determine that you have incapacity. I don't have that place. A judge in your state would make that determination. Again, like I said, it's going to be based on evidence. It's going to be based on a court hearing. The person has the right to attend that court hearing. The person has the right to speak. In many states, not all, the person has the right to an attorney who is going to advocate for that person. So it's really important that the person, all of those steps are taken. It's called due process protections. The due process protections are put in place to make sure that everybody has a fair chance at being heard. And I will mention, it says here at the bottom of the slide that the person has been determined to lack the ability to make or communicate some or all informed decisions. So the person can lack capacity in some areas, but not others. And so that really would be a limited guardianship in those situations. In order to have capacity, we would really want to have a couple things. We would want to understand the choice. We would want to appreciate the consequences of the decision. And so I had a woman at one point, and she was in a high-rise building, and I said to her, which is one of my favorite questions, if there was a fire in your apartment, what would you do? And she said, I'm ready for this. I can do this. I would shimmy out the fire escape. God bless you, you're on the 18th floor. It's quite a shimmy. And so we worked on this. She did not appreciate the consequences of being an 86-year-old woman on the 18th floor of a high-rise and shimmying out a fire escape. It was going to be really tricky for her. So it was really important that I followed up that question with getting an appreciation of the consequences, because for many people, if you said, what would you do in a fire? And they said, I would go to the fire escape, you'd be like, good, all right, we're all set. Making sure the consequences are understood is really, really important. An evaluation of the situation given your life. Okay, so if this happened to me, if I got this surgery, what would the rest of my life look like? Would I be able to go back to my regular activities? Would I be able to still go to work? Would I still be able to hang out with my friends? Would I still be able to live where I'm living? What is this going to look like for me? That's important. And then being able to somehow communicate that choice. And it doesn't have to be verbally. It can be with a communication board. It could be in writing. It could be sign language. It could be any type of assistive technology that the person might use. But there needs to be a way of letting us know, letting the provider know, letting the parent know, letting whoever know what the decision is. And so knowing all of these things is really important in figuring out if the person has capacity. I will say that the person may not choose the same choice as you do. Okay, and that's really important to recognize. just because you don't agree with the decision doesn't make it the wrong decision. And I know you know this, but sometimes it's really hard to remember, right? It's like, why do you not think like me? I think correctly. So we talk about, and I'm gonna mention it in a moment, but I think it's really relevant here. We talk about there being dignity in risk. It's important for us all to take risks. We grow when we take risks. We grow when we fail. We grow when we try something, it doesn't work, and we do it differently and then pass. So to say, I don't want my kid to take risks is probably not the right choice. And that's really hard. But it is something that, as a guardian, you really want to be able to do. Remember, there is dignity in risk. Yes?
Yeah, so I think if someone could, in a vacuum, execute this pretty well,
Uh-huh.
right, so that we have the capacity in a vacuum, but if we have all the other stressors and
Yeah.
factors in play, then suddenly this kind of pathway becomes overwhelming.
Yeah.
So is there a way to kind of parse that out?
I think so, and that's where really the evaluation component comes in, is looking at what else is going on for the person, because none of us make decisions in a vacuum. So figuring out how that works when you have real anxiety, how that works when you have real fear or that you've never tried something before, or how that works when there's other people kind of pushing you in a different direction. So trying to,
Sorry, my question's a little bit different.
oh, I'm sorry, sure.
No, it's right, with all the, she has homework, has to go to work, has to, think about paying bills, right? Each of those are a component of stress in life.
Mm-hmm.
And so maybe adding this other big decision on top of it,
Okay.
maybe she's, the facts is different, right?
Yeah, and yeah, I think so, and that's maybe where you would have a limited situation. Maybe that she's able to manage decisions in her homework and her, some of these other areas in work, but she needs help when it comes to a major surgery or something like that. And so maybe we could tailor a decision-making situation, decision-making support, so that she really gets that. The other option is going back to what I talked about earlier, which is supported decision-making. Really having a team surround her in order to give her the advice that she needs to be able to be successful there. Is that helpful?
Yeah.
Okay. I thought there was a hand up over here. Was I just envisioning it? Let me talk about the pathway towards guardianship. So like I said a couple times now, every state's different, but here's a general pathway towards guardianship. Some sort of a petition needs to be filed saying to the court, hey, there's a person who needs a guardian. Or I'm sorry, this is a person I think needs a guardian. May not, but this is a person that I think needs a guardian. And that could be filed by the family, it could be filed by Department of Developmental Services, it could be filed by the school, probably depending on your school system. Some schools do it, not a lot. So somebody needs to file and let the court know that this is an issue. There needs to be some proof. So we need to have a doctor's visit, and depending on your state, the requirements may differ. So I mentioned an RD, he needed 3 professionals. Maybe you need a psychologist. Maybe you need an MD. Maybe you need a neuropsychologist. So it really depends on what your state requires. There needs to be some sort of a bond filed, and the bond is basically the guardian's agreement that they are going to do the right thing. So it's basically, it's not an insurance policy in the sense that you're getting an insurance policy, but it's your assurance to the court that you're doing the right thing. You sign it, you say, I'm on the up and up. Very often at that time, the court will give you a background check, or give the guardian a background check to make sure that there aren't any felonies or anything an issue. It depends on your state what the requirements are to be a guardian. I'll give you Massachusetts requirement. Are you ready? You need to be over 18 and not a felon. So we have a really high bar, really high bar. So I don't know, look into your background and see if you can make it. Other states, hopefully, or do certainly, require training, which I think is a great idea. I have been in so many courts in Massachusetts where it's like, thank you for agreeing to be your nephew's guardian. Here's your decree, good luck. And I'm like, oh my gosh, that poor person, it's so scary. So that's why I do encourage you to come to the center for Guardianship Excellence. We do all our training is online, it's free. So if you go to the handout that you got, it has our website. We do lots of free training, we do lots of free support groups, lots of free networking groups, opportunities for you to come together and learn. So I do encourage you, just because it can be really scary and you might not know a lot of other guardians. And that's one of the things that I found, especially during COVID, is so many of these guardians were like, I don't know who to talk to about this stuff. I don't know who to talk to when the court doesn't respond to my inquiries. I don't know who to talk to when I can't get my service providers to respond to me. What am I supposed to do? So being able to is either just have a set of ears to say, yeah, that really stinks, or have somebody say, I'm also from Pennsylvania and this is what I've been successful doing, has been really, really helpful for people. So what happens is the petition is originally filed. The court will provide notice to interested parties. So this is going to be the family of the individual and the individual, him or herself. Maybe Department of Developmental Services if they're involved, or something, other kind of agencies that might be involved in the person's life. A hearing will be scheduled. The person may need to get updated proof of incapacity, updated medicals from the doctor, depending on how long it's been from the time that the petition was filed to the time that the hearing happens. Sometimes it's slow. Then there's a day in court. Like I said before, the person has the opportunity to be there. The person has the opportunity to speak. The person very often, depending on your state, has the opportunity to have counsel, have an attorney. And then the court will make a decision about whether a guardianship is appropriate, whether the guardianship is should be temporary or permanent, should be full or limited. So really kind of what that's going to look like. So going back to our friend Artie. When Artie's parents were thinking about the guardianship, there were a couple areas that they were concerned about. So they were concerned about money management. Artie, you remember, has a job, but they don't really know if Artie can budget. They don't know whether he's going to be able to figure out how to kind of pay his own way, pay his bills, do his thing independently. They hope that with the guardianship, they're going to be able to pay his bills and take care of some of that. He's recently said, you know, after this surgery, I am done with doctors. I'm not doing this anymore. And they're like, that's a little scary. So they want to be able to have some medical decision making over Artie. They're also worried about his driving. So he has been kind of half studying, not really putting his whole into it, but half studying for the driving exam. And they want to have some decision making around driving and whether that's appropriate. So some of the things that they'll consider is decisional support. So decisional support could be everything from a guardianship, or the court might say to them, you know, he's got a good team. You know, he's got you and dad in place. He's got a brother. Well, he doesn't have a brother. He has a neighbor. He's got a couple people in his life. Maybe everybody together can support him and help him make the decisions he needs. Maybe that way we can avoid a full guardianship and we can give him as much independence as possible. Because they want what we have here, the least restrictive alternative. And you might have seen that in other places. When we're talking about the least restrictive alternative, we're looking for a way to have his needs met, but not put any more restrictions on him than necessary. So we want to give him as much independence as possible. We want to give him as much decision-making authority as possible, really as much autonomy as possible. And this could be anything like housing. So when we're talking about housing, are we talking about a restrictive institutional placement? Or are we talking about an apartment with friends and maybe some services coming in? Well, that would be a much less restrictive environment, and that's what we're aiming for. He may not do well in that environment. And in that case, we can kind of roll it back. But we shouldn't say, oh my gosh, he might make some bad decisions, I better put him in an institution. That's probably the wrong move to make. And I mentioned before that there is dignity in risk. So mom and dad are hopefully going to learn this and learn that, so maybe not around driving, they'll have to make some decisions with some providers around driving, but around money management. Maybe he can't manage all of his money. Maybe we can't be sure that he's going to pay his rent, and we need to pay the rent or else he'll lose his housing. But maybe he can maintain his grocery money. Maybe he can maintain some spending money. So giving him an allowance and seeing how he does with that, and if he does well, maybe we can ramp it up and give him a little bit more money. The goal here is restoration. So if we could restore his decision-making authority, that's best case scenario. We would love to see that. What you're going to see is that even though there's a lot of crossover between what a parent does and what a guardian does, there are also some differences. The legal relationship between a guardian and their person is very different than the parent relationship. You are given a decree, you're given an order from the court that lays out what your authority is. And that specifically gives you powers that in things that you can and should not do. You're not given that as a parent. You're just supposed to figure it out. So in some ways it's a little bit helpful. You're like, oh, at least I have a roadmap here. As a parent, you don't have to report much. And whereas with the court, with the guardianship, you do have to report to the court. So you have to let the court know. For a parent, that can feel really gross. Who the heck is the judge to tell me that I need to report on my kid? Are you kidding me? This is my kid. But the court has the ultimate authority to oversee the guardianships. And we've seen in some states recently some backlash where the court was a little bit sort of like, you're the guardian, do whatever you want to do. And some guardians have gone a little bit rogue. So we are seeing more states really trying to oversee these guardianships and make sure that people are doing the right things, are making decisions with the person instead of just simply for the person, making sure that the person is given the least restrictive alternative, all of these things, person-centered guardianships whenever possible. And that's really kind of the movement that we're going in, or the direction we're going in. Knowing and following the rules of your court is really important, knowing what's expected of you, knowing if you're supposed to do a report, if you're supposed to do a hearing, all of that is important. In the guardian's world, we're supposed to be person-centered. So there are skills, tools, or assessments that we can use to figure out what the person can do and what the person needs help with. And that's a really good thing to do, is on a regular basis, try to figure out what's going on with the person, how the person's doing, and get services in place or help in place if the person is having trouble with certain areas. I had a person who I was appointed for because they really had no financial decision making. They really had a lot of trouble with financial decision making. And it turns out it was because they had never really been taught. Are you just supposed to know how to balance a checkbook? And checkbooks aren't intuitive. So being able to explain to them what was expected, how to do it. And like we sat and did monthly bills, month after month after month, until finally I said, okay, well, what should we pay? And then for the next month I said, can you write the check? And then eventually we were able to say, you don't need me anymore. This is great news. You can do this. And so the training, the skills training was all this person needed to get out from under financial guardianship. It was awesome. So being able to really assess what the person needs and give the person support in helping them get their independence is really a great thing to do. The guardian should find appropriate housing, should perform informed consent. When we provide informed consent, we need to be informed. And so very often, I'm an agency guardian. I work for an agency that acts as guardian for 80 people. And providers will sometimes say to us, you ask a lot of questions. You bet I ask a lot of questions. If I'm going to say yes or no to a surgery, I need to know exactly what's going to happen with that surgery. And I am not a surgeon. As a person who's not a surgeon, I need to ask the questions. And it scares me to think that a lot of people aren't asking the questions. So I encourage you to be informed and not be intimidated. These doctors are like, I'm busy. I've got things to do. You're lucky I'm returning your call. And you're saying, no. You have to make the time for me. I need to understand the decision before I can give consent. And you can do whatever, homework you need to do, whether it's Google or whatever, asking a lot of questions, but that's not going to give you the answers. You need to be able to ask the questions of the doctor. So the other side of what we do as guardians is we act professionally. So we provide professional excellence. We look for a way to make the person as independent as possible. We advocate for the person's rights, needs, and for justice. And I'm going to show you in a moment a list of rights that the person maintains. We try to stay out of decisions that are not in our lane. So if the person is able to make a decision, we don't say, oh no, I'm the guardian. I had a colleague, a friend, tell me, I'm really tired of my guardian. She rearranged my spice cabinet, and I can't find anything. I'm like, well, what the heck was she doing in your spice cabinet? And she's like, well, she's my guardian. She decides where things go. Oh, no. She has no right to make decisions about whether you put the sugar on the left or the right. She makes decisions about major things that are in her decree. It does not say spice cabinet in her decree. So stay in your lane. If you can give the person an opportunity to make a decision, that's great. Do that. And then opportunities to end the guardianship when necessary. I know I have until 11:45, so I have 7 more minutes. I want to talk about the rights the person maintains when they have a guardian. So a couple years ago, a bunch of guardianship advocates put together a Bill of Rights for people with guardians. I love it. It was a really cool thing to do. But it's like wordy, it's a little legalese, it's kind of big, it's 5 pages, it's 21 rights, it's kind of big. And so my organization was like, can we make this something you can stick on a fridge? I'd like there to be a visual. So we broke it down to 8 categories. The person maintains the right to participate in decision making, and that can be at whatever level the person is at. So it could be really at a high level if the person is able to function at that level, or if they're just able to say, I want a red shirt versus a blue shirt, that's fine too. But there are decisions the person should be allowed to make and help make. The person has the right to privacy. So just because they have a guardian doesn't mean the guardian has the right to take down their doors of their bedroom or read their emails or listen in on their phone calls. They still have the right to privacy. The guardian should protect that person from discrimination, and that's really important. So there are certainly people and agencies and organizations that discriminate based on ability and disability. The guardian has to be aware of that, and has to be aware of issues of race and gender and sexuality and all of these areas that the person might be discriminated against, and be a strong advocate in those areas. One of the things that bothered me most, now this is the second time I'll mention Britney Spears, and so that's, I'm sure, what you came here for. One of the things that bothered me most about the Britney Spears testimony when Britney had a guardian was she said, I never knew I could ask the court to change my guardian. I didn't want my dad to be my guardian, but I had no idea I could ask to have somebody else be the guardian. And I was like, oh no, they are not serving you well. If you don't know your right to have access to legal advice, to have your guardianship reviewed by the court, then they have not served you well. So the person, even if you are the parent guardian, the person has the right to say to the court, I don't want my mom to be my guardian. I'd really rather my uncle be my guardian. I'd really rather my neighbor be my guardian. If there is coercion, if you have a neighbor who's like, I should be making you decisions, then you've got to fight back, you've got to push that. But there might be a separation where somebody wants to have a little bit of privacy from their parents. I had a person who was really embarrassed about the fact that her mom was so involved in her reproductive and sex life. Because mom was the guardian, Mom would go into GYN appointments with her, and she was like, this is embarrassing. I don't want this. And so she said to the court, I would rather somebody else that wasn't my mom be the guardian, just so I have some privacy. And the court was like, I understand. And mom is still involved in everyday life. She's still a part of, but she doesn't need to know the ins and outs of daughter's birth control. And that was really important to the daughter's sense of self. Freedom of religious expression. So if the family has always practiced a certain religion or has never practiced a certain religion, that doesn't mean that the adult with the guardian has to do that same thing. So they have the opportunity to explore just like every adult does. This is probably going to be the hardest, and I kind of mentioned it with a gynecologist appointment, but the freedom of love and sexual expression. This can be really challenging. We have a person that we were working with who has been having a real challenge with his mother guardian because he was born female and mom is still calling him a girl. And there is a real issue around transgender identity. So the
If the mom's calling him a girl, and
he was born female and identifies as a man. Identifies as a man. And the mom is saying, my kid, my decision, my rules, and we're like, no. That's not how it is. You are the guardian. You are the decision maker. You have to listen to what this person is telling you. This person is telling you what their identity is, and that's really important. So this might be the hardest for parent guardians, family guardians, around sex and gender identity, but it's a really important area to kind of work with. The person has the right to a safe and sanitary living and working environment. So making sure that the person has the best appropriate housing that the person can have is very important, and that needed services are provided. These are all areas that the guardian should advocate for. And then finally, in some situations, the guardian may need to either step away from the guardianship or may no longer be able to be the guardian. So I do want you to know, if there is, you should look in your state because every state is a little bit different. There may be, if you're a parent guardian, an opportunity to name somebody as a co-guardian. That might be a really good idea for you. So it can be tricky if maybe you and your co-parent want to be guardians, you and one of your children want to be co-guardians, whatever it might be. But that way, if something happens to one person, there's still another guardian in place. That guardian knows the person very well and isn't randomly kind of put in place in an emergency, and there could be a gap in services or whatever it might be. If you do this, and if there's one thing I tell you, I want you to hear this. If you do a co-guardianship, I encourage you to make sure the guardianship says mom or dad, John or Susan, not John and Susan. Because if it says John and Susan are going to have to sign every consent. And if John and Susan are not in the same place, that could slow things down. So I encourage you to make sure it's an or situation rather than an and, so that you can kind of move things along in a speedy way. So that's a successor guardian. We talked a lot about supported decision making, and if you have questions about supported decision making, we have a lot of resources that we can share at the center. And then great situation is restoration of rights. So whenever possible, if we can restore some of the person's authority or all of the person's authority, that's a wonderful situation to be in. So as a kind of last slide, I'm going to just give you a little bit of kind of closing thoughts. The transition from being an advocate for a child to a legal guardian, it's tricky, and I would love to be able to say I've got this roadmap for you. It's a windy map. So you're going to be patient with yourself. You're always going to try to figure out what the least restrictive alternative is. So if there's an option where you're able to keep some of the person's decision making, even in areas that you think are small, it can still be a win for the person to be able to be in charge of some things. And then I'm going to remind you again that there is dignity in risk. So if you allow the person to have risk in some areas of their lives, it can help them grow as people. I mentioned before that effective guardians do what is important for the person as well as what is important to the person. So you're going to talk with the person about what's important for them, what their needed services are. But you're really going to understand the person to talk to them about what's important too. I will tell you that as parents, we sometimes assume we know. This kid's grown up with you. This kid has been in your house for 22 years. Of course you know what's important to the person. The kid's getting older, the kid's changing, the kid's growing. The kid has new friends, the kid has new opportunities, experiences. Get to know the person as an adult now, and that can be really eye-opening. Involve that person, involve that adult in the decisions as much as you can. Focus on whatever the person can do instead of what they can't do. And then educate their providers and staff. Let the providers know that the person has the right to be involved in decisions. If there's a care plan meeting, make sure the staff knows that your adult child is going to be there. Don't be having those meetings without the adult child. Encourage whenever this is my biggest pet peeve, and I bet it's yours too. If you're in a doctor's office and the doctor is asking you what's going on instead of your child, redirect that doctor, and if that doesn't work, you find a new doctor. Explain to the doctor that this is your patient, I'm not your patient. And then know what your court and your state expect of you. You don't want to be getting that letter from the court saying, come see me. You want to make sure that you're doing what the court is expecting of you. So you're going to provide your reports on time, you're going to be accurate, they're going to be timely, and you're going to keep within your authority. You're not going to overstep your authority. And then I will just share this with you. The Center for Guardianship Excellence, which is my organization, provides research, training, tools, and networking. So grab your handout. Make sure you check out our website because everything we do is offered for free. So if there are questions you have, if there are skills that you would like to develop, we would love to see you there. If you are interested in supported decision making, we have training on what it takes to build a team, but we also have an interview on our website with Jonathan Gardner, who was the other speaker of the SDM presentation yesterday, who does SDM himself and is so powerful. So if you want to see what it looks like in real time, that would be really cool. Yes?
Hi, I'm sorry to interrupt. I just wanted to say we've recently gone through the guardianship, however you know it.
Process,
It
sure.
sucked. It was hard. We were shamed. You know, everywhere we asked for help, it was like, oh, no, you just want to control the kid. And that's not what we want. Nobody wants to do
No.
that, right? We want best for our daughter. However, we're in a special circumstance because, you know, if seizures returned, the brain capacity doesn't work, you know, the same. If their meds are off. So with just the supported decision making, we felt, you know, there was some kind of chemistry that wasn't right on that day. If they got the phone call, you know, from the Prince of Saudi Arabia who needed money, that she would say, sure, you know, I would love to help you and give him her financial information. So we do it more like to protect her. So I would say 9 times out of the 10, we are doing supported decision making and kind of just have guardianship in case something ever goes wrong. You know, where we need to step in. So I don't necessarily think it has to be a either or type situation. I think they work really well together. Just a heads up, you know, it doesn't have to be a negative thing.
Supported decision making at its heart is talking to the person about what their wants and needs are. And that's what we've kind of talked about. Person-centered guardianship is talking to the person about what their wants and needs are. So if you incorporate the person into all of their decisions, you're using a form of supported decision making within your guardianship. And that's a great way to do it. That's a great way. And then you have that safeguard in case there's a situation that gets out of control. That's great. Yes.
So how long does this process take? The reason I ask, you know, we need to make a decision for our daughter on guardianship. Is it something we start at age 14, 16,
You should probably start exploring around 16. And you might be able to talk to your school about what resources are in your area, things like that. The actual timeline from the petition until the time the guardianship is appointed, depending on where you live, can take months. It can take 3 to 6 months, something like that. So you certainly don't want to start when she's 17 in 10 months. You definitely want to give yourself some time and know what the process is in your state. Anybody else?
What state do you live in? I'm in Virginia. Sorry about that.
Yeah.
Yeah, I mean, it does seem, and I get it, and I think it's just because people have taken advantage of being guardians, I'm sure is why it's so strict, but I feel like us as parents being here, I think it's right?
Yeah, it's really challenging. There is a lot of stigma around guardianship. We hear it a lot from the providers we work with, and everything like that. Is we don't like guardians. So there's definitely a stigma because there are some bad actors, and the bad actors are the ones that get in the news, and the good actors don't. And so there's a lot of pushback there. But trying to do supported decision making within guardianship is really a great move. Yes. You don't have the authority to make a decision for the person if you don't have a guardianship. A hospital may say, "Well, your mom, sure, you can do it," but in most legal situations, legally, you need to have that. Yep. Yes.
So I was just wondering, our daughter is 20. We did power of attorney for medical and financial, so we can help her make those decisions and sign things with her consent. She loves it. She could fire us.
Yeah.
She would like it. But since we've done that and she's now 20, hearing more of this and talking to different people and stuff, we're thinking maybe, going towards like a guardianship, similar like what she's saying, just because Nellie doesn't know strangers, so she would willingly help anybody who she thought needed help, even if they were trying to take advantage of her. So now that she's 20, is it too late? I guess is my
Certainly.
question.
No.
We can do guardianship at any time as long as we can go to the court that that's what she needs.
Yeah, you certainly, there's no timeline. But I will say that you would be able to go back to court and have the court affirm your power of attorney if she were to start giving money to the Saudi prince. There's a pretty good chance that you can keep that power of attorney in place and avoid the need for guardianship. That probably will work well for you. Again, I'm not an attorney, so you want to speak to somebody in your state, but very often we can avoid guardianship with powers of attorney.
And I think, just to add on your thing, I think talking to an attorney and developing a relationship when they're in their teens is a good thing. We did it, so I have a son who is like a year and 10 days older than Nellie, who is on the autistic spectrum. So we started the process with him because we just weren't sure. And so we knew that attorney, we were comfortable talking to them, and we said, okay, next one, here's our daughter, this is the deal. And he goes, okay, if you want to do like a guardianship, it's going to be easier than trying to prove it for my high functioning, spectrum there. But he also offered all those different things. So having that relationship, being able to talk to him, because he knows all the rules of like our state and what it is, I think is important. So I would encourage that for anybody who's got like teen kiddos who they're thinking about. Develop that relationship with an attorney and just go and talk to him and say, hey, this is who I am, trying to weigh my options. What do you think? I think would be a good idea. Yeah, because he did say then, okay, here's the deal, when do they turn 18? He said, all right, let's schedule you an appointment. And it was like right after they turned 18, since we were doing power of attorney, and we were able to get that going. And the power of attorney is it's just in the office. Well, in Illinois, I should say. In Illinois, it's just in the office of the attorney. Nellie said, yep, I'm good with that. The attorney said, are you good with being her POA for this? Yep. No, mom, or, we did 2, you have a primary and a backup, and it was done right there in the office, and easy to do. But that's not going to work for everybody, and not every state's rules are the same. So, but the attorneys in their state are going to know. But the advocates are great help too, and I kind of use them without a officially doing it with special ed teachers, so I know they have kids on the K, or I need to do.
Yeah.
But
That's
yeah,
great.
that's what I would recommend, talking to them, like, while you're in those teen years to figure it out and have a plan, so that adulthood hits, you're not like, trying to figure it out.
Good advice. Yes.
So, let's say you're a guardian of your son or daughter in one state, applies to do that. All of a sudden, either you or your daughter or both move to another state. What happens there?
It's easier if the guardian moves to another state. If the person who has a guardian moves to another state, the guardianship is going to have to be established in that other state. So there is a law, the Uniform Jurisdiction, Guardianship Jurisdiction Act, something like that, that allows some states to have guardianships work in, like, the guardianship process work. Okay, I'm already the guardian of my child in Massachusetts. Can I do it in Connecticut? So there are some laws that make it a little bit easier to move that process, but you're definitely going to need to speak to an attorney. Yep. It's the guardianship is based on your county within your state, so it doesn't leave the state. It does move county. I don't want to speak for every state, but most states allow you to be outside of the county, but still go back to the primary county for court cases. Yeah. Because that would just be so brutal if you had to move courts every time you changed locations. Well, that was easy, right? Thanks everybody for coming. This was really helpful.